I'm going to ask you all to bear with me. I've been, Dallas to Denver to Dallas to Houston the last 5 days, and I think my sinuses have caught up with me, so with a little scratchy throat, but I've got my water and I've got my mentholyptus, and we're going to get through this. Find my, is the remote, oh, there it is. So here we are, Landman talking to a room full of attorneys about ethics. What could go wrong? Nothing at all. Nothing at all. Okay, I'm going to talk a little about the goals that we want to approach at this time. I'm not going to get real deep in the woods as far as about talking about the documents as to construction and things like that. That's y'all's periphery. I'm going to take the document that y'all prepare and I'm going to go out and try to get it signed for you. So I'm really going to be looking at what the Landman does is his part of the negotiations involved in these documents, oil and gas leases, ratifications, pooling agreements, production sharing agreements, these types of things, and what our responsibilities are, our ethical obligations to both the client and to the opposition, to the other guy. Let me see. The Landman is known as the point person. Some say he's the face of the industry. We're the guys that seems to go out there first as far as trying to get the leases, to get the right-of-ways, to get the easements. We deal, of course, with the competitors, and then we negotiate exploration agreements, joint operating agreements, farm-outs, kind of all of the above. We do this ethically. That's the plan. And our basis for that is what? It's the AAPL Code of Ethics. We have a standard of practices and code of ethics. That's where we start from. Kind of as a synopsis of that, we start off with Section 1. This tells us what we're supposed to do as far as dealing with the public. This can be landowners, industry partners, even those outside the industry. We're supposed to deal with them in fairness and honesty. Section 2 tells us, as far as treating the competition, honesty and courtesy. We're supposed to act in good faith in our dealings with industry associates. The Landman will not betray his client's trust by turning confidential information to personal gain. He or she will exercise good faith and loyalty to the client and not act adversely or in conflict with the interests of his client. We also have some strict rules, guidelines, if you will, about how we interact with each other in the industry as far as Landman. We do have an ethics committee. There's a chairman that's known. There's 11 to 13 members of this committee that are not known. And it's not used a lot. It's used sparingly, but it is used, and it's used every year. And I guess I was on the AAPL Board of Directors. It's been over 10 years now. And we had two situations come up where some members lost their membership because of unethical practices. So we're to watch after these people. You know, there's about 20,000 members of the AAPL, and the way it used to be, if you got kicked out of the AAPL, you just wake up the next morning and you're still a landman, and it's still that way. But through the years and through a lot of the work that we've done within the AAPL, people really that are in the AAPL don't want to lose their membership. We have, I think I counted about 5 clients, significant clients, some that are government, quasi-government, some large, mid-sized E&P companies that require all of my landmen to be members of the AAPL. It's important to them that we have some basis for standards of practice and code of ethics. Also, excuse me, 2 of these entities actually give us a schedule of payments that are based upon our certification that we get within the AAPL. CPL, it may say CPL 20 years experience, so much per hour. RPL, 10 years experience, so much per hour. So when you start talking about money, there's also that incentive that people want to maintain that membership and be ethical. So this is a joke, so don't take it seriously. But I took a course in ethics, but everything was contradicted by the course I took in Negotiations 101. I went to Texas Tech. They didn't have that course, so someone told me, said, now if you put these in there, you better tell them it's a joke, because these are attorneys and they're going to take you seriously. So you know not to take me too seriously. Okay. What about the landman's responsibilities to his client and the opposition, the other guy? Well, when does a client become a client? It was a couple of years ago, actually it's been about 3 years ago now, I was deposed as an expert witness, and one of the questions that was asked of me is, when does a person or a company actually become a landman's client? Understanding that this is a different animal between an attorney and a client to some extent, and how should he be treated before and after that point? Well, from that deposition, I penned an article that was published in the Landman magazine called When Does a Client Become a Client? And the highlight of that article was built around confidentiality. When does the obligation of non-disclosure kick in? Here again, I went back to the Code of Ethics. That is my pivot point. And it says in there explicitly to treat, I call it the other guy, it doesn't say the other guy, but the opposition, in a fair, honest, and courteous manner. However, if there is not a land service agreement in place that covers confidentiality, there is only the codified obligation to be fair, honest, and courteous, as well as the expectation to keep competition at a high level. And that's explicit in there, to keep competition at a high level. So once you've established the contractor-client relationship, i.e. a land service agreement with the confidentiality language, the landman shall exercise good faith and loyalty and not act in conflict with the interest of his client. Now, just kind of stepping aside, you say, okay, well, what's a land service agreement? What we use in our company is the AAPL promulgated form Master Land Service Contract. It was prepared by attorneys. I wouldn't be surprised if George had some part in that, but it delineates out the confidentiality language, what the expectations and obligations are for both parties, and we add our fee schedule to that also, and we usually get a retainer of some type, and we add that in there. But we also understand that you can have a service agreement maybe by emails, and that's done all the time. I would suggest, though, if you get an email and you're a landman and said, I need you to go, even if it's just go make some get some copies for me at the courthouse, here's the legal description, I'd still get something in there that has some, say, I'll be happy to, in your return email, here's confidentiality language and whatever other things you want to put in there that we agree upon. So that may be sufficient. And then there's also the verbal or oral contract, which I don't like. It starts out well, but at some point in time, parties tend to forget intent, and then you've got to go to this guy, this judge, or this jury or something to explain what your intent was, and I don't like that. And y'all might like that since you're attorneys, but I don't like that. And then there's the course of conduct, which maybe over a period of time you have repeated services and the compensation paid is the same, and some may consider that after a period that's a form of contract. Here again, that's one I'd rather not do and go back to the actual service agreement. Okay, ethical obligations to the client. Sometimes it isn't that obvious. There was an example. I was taking leases for a client. It was our company several years ago. It was out in the Permian Basin. It was very busy play at that time. Client was Company A. We were almost done with the project, taking leases. And in fact, I think we were finished actually. And then Company B called me and said, hey, you got any landmen out there? We've got a big project. And theirs was even going to be bigger. in their description, the properties were pretty close together, the AMIs, maybe even a little overlapping. But I said, well, let me get back at you. Called Company A because that's where my obligation was. That's my first obligation. I had a lease or a land service agreement in place with him. I didn't want to create a conflict. I told him the situation, and in this case, he said, you know what, we're finished, got all the leases we want, knock yourself out. So we were able to do that. A lot of times, that doesn't happen. Usually these are competitors, especially if it's a busy play, and all you'll do is make them mad, at you if you try to play that game. When I was a VP of land at a publicly traded company, I was basically Company B. I had a similar situation. I didn't even want to go down that road, and so I just got another land service company. Okay, the mission: fulfill the landman's duty to the client while dealing with the opposition with honesty and courtesy. Now there's a balancing act that starts. Because as my client's landman, I have the explicit obligation to perform my duties under the best of my abilities in a good and workmanlike manner with diligence and in accordance with good industry practices and procedures. On the other side of the scale, I have a responsibility to adhere to the established rules of honesty, courtesy with the competition, the other guy. Now, I want to emphasize that honesty doesn't require giving away confidential information. And an attorney gave me a good quote many years ago that I've kept. He said, while a landman may feel compelled to explain the effect of a contract or a provision in a contract as part of the negotiation and persuasion process, the landman cannot have a duty to provide interpretive analysis and advice to the opposing party. And I think that's pretty succinct. But over the course of time, I go to Mel's Diner quite a bit. There's an acronym I picked up many years ago. MEL, first, is my approach moral. I always kind of defer to the golden rule: do unto others. Good way to go. You can almost just make a whole ethics presentation based on the golden rule and have everything about covered. Second, is it ethical? So what are my obligations under the code of ethics that I signed off on when I became a member of the AAPL? And third, but of course not least, is it legal? Are there going to be any conflicts created? I just don't want to go to the courthouse unless I'm going there to run title for some of you guys. The landman shall avoid business activity which may conflict with the interest of his client. Which, did I go backwards? Oh, no, that looks pretty good there. Yeah, the way I see it, unethical ethics are better than no ethics at all. It's a joke. It's a joke. I gotta remind y'all. Well, I liked it. Okay, get that lease. That's our bread and butter. No lease, no grease. Remember those bumper stickers that we used to hand out at the AAPL? Well, actually, this was Terry Cross gave me this idea. I love this. Toby Keith. Are y'all familiar with this song? I Love This Bar. He was talking about the folks, the winners, the losers, the smokers, the boozers that come into his bar. Gave me an idea of the Landman version. I've got hustlers that I deal with, fighters, hard traders, some that are desperate for cash, some that are no mood for a fight, and some that are. There's some who have a lawyer in the family, and that's always fun, and especially when he's not familiar with oil and gas. Mineral owners that think they know everything, and some owners that are rich, others that are sophisticated, and some that are neither. Some may engage an attorney and or have their own form of oil and gas lease, which is almost every time guaranteed to be the most onerous oil and gas lease you've ever seen in your life. Well, the ones that aren't rich or sophisticated, they don't know where to start normally, but inevitably, when you keep talking with them, negotiations will break out. And clearly, I'm going to have, as the landman, I'm going to have information that the potential lessor does not have, and he or the mineral owner is going to have information that I probably don't have. And as we noted before, honesty does not require transparent disclosure of confidential information or subordinating you or your client's interest to the other guy's, the lessor's interest. And while the negotiations may include discussions regarding the effect of various provisions, neither of the party has the duty to protect the interest of the other. which is a good title for this next slide. We don't have a duty to protect or represent the interests of the other guy. However, there are sometimes efforts to impose that kind of a duty on the land, onto the landman. An interesting it is just kind of an analogy of what I'm seeing more and more of across the country, especially as the non-conventional plays have expanded. Here's one the Ohio House tried to pass. It was House Bill 493. This was about 3 years ago. Had it passed, the requirement would have been, I call it the thorough explanation bill, because the landman would have to thoroughly explain how drilling works, thoroughly explain all oil and gas rights, thoroughly explain all parts of the lease, thoroughly explain and provide a list of all chemicals that may be used on his property if a well is drilled, and remind him you have the right to get an attorney, which, you know, that's good for y'all, but sometimes make it harder for me. And there's just a whole laundry list of these that were in this bill that's in the paper there. Fortunately, it didn't pass for the time being, but the premise that mineral owners do not stand on equal footing with the landman in the leasing transaction continues to result in extra scrutiny being placed on the landman's conduct in that area. Okay, go get that lease amendment. Okay, it's always harder to go back and get something changed, especially if it's deemed to be worse than the status quo. It's kind of a landman truism. One of my first projects, I was hired as a land manager back in 1997. The company decided, we need you to go out to the Panhandle, I believe it was Gray and Wheeler County. We've got about 30 lessors out there, and the leases, we're really nervous about it because they, for the liability standpoint, because they have free gas clauses. And are y'all familiar with free gas clauses? They don't do them anymore, but back in the 30s, 40s, 50s, it was just a little, you know, chip that you threw the lessor, a little goodie, and they could hook in a line to the flow line. In some cases, they did directly to the wellhead, and run that to their house and light their pilot light, or some of them used them to irrigate. You could hook it up to machinery to irrigate your land, and it was great. They loved it. And the lessee didn't care because, you know, he was going to flare that gas anyway, so if that helped get the lease, great. Well, we didn't like it because houses started blowing up, and so liability went along with that. And so they said, we need you to go out there and get an amendment getting rid of this. Well, I wasn't really very well received by most of them because they liked their free gas. Especially at that point in time, gas was more than a nickel or being flared. And so what I did, I went out there prepared. I thought pictures are worth 1,000 words. So I had pictures of houses that had blown up. I had some carnage pictures, but I thought that was going over the top. So I had that, and then I had money. And so the combination of the pictures and the money, sitting down and talking to them and explaining to them how this would be probably better for all concerned, the majority of them signed the amendment, and we got rid of that. There were a few that didn't want to do it, and ironically, about 5 of those, they had a garden hose that they used. Yeah, really. So one of them had duct tape around the garden hose. Running gas into the house from the flow line, and I'm going, oh my God, well, can we at least plumb this correctly? Like, well, sure. So we got to plumb it correctly and put some safety equipment on it and everything. So anyway, that was interesting, and that was definitely a challenge for my just getting with this company. But bottom line, I just try to play it straight. Give them the facts. Don't over embellish, but tell them here's what we're dealing with. Be prudent and be thoughtful with the information that I give them. Okay, it's always fun to get a non-participating royalties interest ratification. Not if he's the drill site, but acquiring the right to pull NPRIs. It's a critical task for the landman, especially in Texas, where forced pooling is an inadequate tool for dealing with these issues. Since Texas doesn't really have forced pooling, I defer to y'all on that, but I think there's a Mineral Interest Act or something like that that's maybe been used a few times, but basically we don't have that. So when the owner of executive rights executes an oil and gas lease, it binds the non-participating owners to all of the terms of the lease except for the pooling authority contained in the lease. In the absence of a binding pooling agreement, the NPRI owner who owns under the drill site is undiluted by the pooling. So if he knows where that drill site's going to be, he's probably not going to want to sign off on a ratification unless you can give some special considerations, which are usually green, and sometimes you got to pay a lot of them. But that's part of the negotiation process. So I always like to get the NPRI guy who is not the drill site, because he comes a running, and he's more than happy to sign off on the ratification. So what do I do when I do have the drill site NPRI? I try to be positive. I might say something like, by ratifying, you may give yourself the opportunity to end not just this well that's on this tract here, on your tract, but if there's a well drilled on your neighbor's land, you're going to be in that one too. In fact, you'll be in all the wells that may be drilled in the unit. So I try to appeal to the greed. I don't ever promise that there's going to be wells drilled. Got to be careful about that too. I don't try to be negative. I know when I've seen in the past where a landman said, hey, if you don't sign this, the next well on your neighbor's land, that might be a barn burner and you're not going to be in it, and you're going to have all your oil drained and everything. People, human nature, what I've seen is they tend to pull back. And you're trying to pull something on me. So I just try to be positive and appeal to the greed. You do what you got to do. Ethically. Okay, get that production sharing agreement. So now we've got a PSA that we get to deal with. I think Devin started this back in 2012. Actually, kind of ingenious. I'm still getting used to it, though. Operators, they might find themselves facing the dilemma of needing to drill one or more horizontal wells across tracts that they have under lease. But the leases do not provide for or may even prohibit pooling, and they have not been able to negotiate a standalone pooling agreement with all the lessors. So there's a viable alternative that is in play right now, the PSA. The purpose of the PSA, is to bypass the need for express pooling authority and instead contracting as to the method by which interest owners will share in the production, coming up with some kind of formula that they can come up with. So the Railroad Commission, they came up with this form, PSA 12, which kind of looks like a P12, which is your permit for pooling. There is a requirement. You have to have 65% of all mineral and working interest owners in each lease, unit, or tract to sign off on the PSA. So what am my sales pitch when I go try to get an interest to sign on this? I just say, this is good because it encourages development, it prevents waste, it prevents the drilling of unnecessary wells, it increases ultimate recovery of hydrocarbons, protects correlative rights, and potentially it allows for the development on tracts that are already pooled and would otherwise not allow for a horizontal well. And it gives you a voice in the allocation of production. I will note that there have been cases filed and prosecuted regarding the Railroad Commission authority to issue PSA and also allocation well permits that's not yet promulgated. I got that information from Roger Beecham, so if that's not accurate, you can blame him. Okay, do's and don'ts. I do want to say these aren't necessarily the top ones, but I think for this presentation, these are kind of the direction I'm going. The first one is going to be disclosure. And I'm not saying you got to get full disclosure, partial disclosure, but I call it practical disclosure. Information that honors the contractual commitment to the landman's client and still deals honestly with the other side. It can be done. Now, note, and here's a little, I've been told to say this also by a fine attorney. I have been advised that there may be times when full disclosure is required by law, but for this discussion, I'm referring to the negotiation discourse between parties when full disclosure is not required. Okay. The case. Interesting case. Pan American versus Maud Smith Estate. Facts of the case: Pan American hired a landman to take leases on its behalf, provided him with an office, a telephone, company email address, and they made him the point man in negotiations and never informed the landowner of the landman's lack of authority to bind it to a lease. Where there was an exchange of emails that occurred between Maud Smith's attorney and the landman, and there was a lease offer and terms that were included in this email. The attorney accepted the terms on behalf of his client, Maud Smith, accepted the offer, mailed the executed lease back to the landman at Pan American's offices, and prior to paying the lease bonus, the price of crude oil dropped. Okay, so Pan American said, we're just going to cold draft this. We're not going to pay this. So they didn't. And then on top of that, they said the landman did not have general power of agency. However, the court said that the landman had apparent authority. He had apparent authority to act on the behalf of the principal and to bind the principal. The principal either knowingly permitted its agent, the landman, to hold himself out as having authority to negotiate the agreement, or demonstrated a lack of ordinary care as to clothe its agent with the indicia of authority to act on its behalf. Well, the trial court ruled for Maud Smith, and the Court of Appeals affirming that trial court ruling. Now, in my opinion, there was a couple of ways they could have avoided this train wreck. If you had entered into the promulgated AAPL Master Land Service Agreement, it says explicitly in Article 2, relationship of the company and the contractor, in the event that services provided by a contractor include the acquisition of oil, gas, mineral leases, etc., for the account of the company, the contractor shall act as agent on behalf of the company, but shall have no authority to bind the company in any other manner or for any other purpose, or to enter into the contract or agreement on behalf of the company. You can disclose this up front. In this case, it would have been Maud Smith's attorney said, hey, we can negotiate, we can get everything put together, but I can't bind us on this, and that would have avoided that situation. Number 2, do honesty. It's always a good policy. Do not incorporate deception into your presentations, distorting and twisting facts to serve your own purposes. There's a contest I heard about recently, but it's been around evidently many, many years. It's the annual World's Biggest Liar competition. It's in Cumbria, England. And over there they call lies porkies. I didn't know that. That's interesting. But anyway, they have competitors from around the world. They get 5 minutes to tell the biggest and most convincing lie that they can. Now, there's a true fact about this competition. Politicians and lawyers or barristers are not allowed to enter. Why? Because they are judged to be too skilled at telling porkies. Now, I do have no doubt if Landmen were over in the UK, we'd be on the no-lie list too, but as it is, it's just politicians and attorneys. So what are some questions that I tend to get, and I hate getting them, but you're going to get them when I'm out there? Said, who are you leasing for? Because the majority of the time, my client has me taking leases in my name or another name. Because he doesn't want people to know. This is just something he doesn't want competition to know that he's out there doing things. Another one is, how soon is the operator going to drill? And then you always have, now I want the highest royalty and the highest bonus that you're paying out here. Well, okay, so first off, I got to go to my client, and I'm kind of get the ground rules before I go out there. So if he tells me, I don't want you telling anybody who we are, we're under the radar on this. This is a stealth mission for you. I'll tell him, I said, hey, for competitive purposes, my client prefers to be anonymous at this time. This could be very helpful for the development of this area. And in turn, it's going to help you. So you don't want to mess this up, do you? And then how soon is he going to drill? Well, listen, we're getting a 3-year lease. He wants to drill out here. So if he drills, we're going to sure drill within the 3 years. Now if my client says, hey, you can tell him we're going to drill in 6 months, I'll do it. But more often than not, they don't want to be pigeonholed like that. And then as far as telling them what the highest royalty and bonuses are, I usually tell them, unless the client says don't, because there's neighbors, and they're all going to know. And believe me, they always know. So I find that just to be honest. Honesty is the best policy on that. I have asked sometimes, it depends on the situation, if we can include a favored nations clause when it comes to that, and then that would give them a warm and fuzzy. That can add up to a lot of money, though, so prefer not to do that if possible. And then you always have the gray areas, the dilemma. Gosh, I got to be honest, I got to be truthful, I don't want to give away confidential information. So your wife comes in to show you her new outfit, and she asks you, honey, does this dress make me look fat? Well, what if it does make her look fat? Are you going to tell her the truth, you brave man? Probably not. That is if you're smart. You all are smart. But maybe you have a response that might be, baby, you look great in anything. Now, technically, it may not be perfectly honest, but it doesn't appear to me to be ingratiating you at her expense. Perhaps that's the point to be weighed when confronted with a like question from the lessor. Is this the best thing for me to do, to sign this lease? An answer the landman may want to consider might be, that is, of course, something you need to decide for yourself, but I can see where it could be very beneficial to you. More often than not, my sense is they're looking for reassurance that they're doing the right thing, and I'm more than happy to give them that reassurance. Okay, what's a don't? We kind of hit on this earlier. Misrepresentation. Stay away from certain phrases that some of us may use to embellish the results that a signee may enjoy if certain documents are executed, such as, and I had said some of these before, all of your neighbors have signed up. You don't want to be left out. Or if you don't sign, then all of your oil is going to be captured by your next door neighbor's well. And hey, once you sign, we'll drill that well, and you're going to be receiving some really nice royalty checks. Now, any one of these phrases could be correct in certain situations, but I would suggest going very lightly on saying those if you say them at all, because they still could be construed as being coercive and maybe at some point in time come back and haunt the landman and his client down the road. Creative editing. This is, I thought long and hard about before I put this because I'm kind of telling on myself, but I didn't do anything wrong, but I was tempted. It was a situation several years ago. Actually, I was a company. I was a land manager, and we were moving a rig on within a week and came across a ratification that a guy signed as an individual, but he also needed to sign as a trustee. And there was a lot of room on this document. And this guy was not a nice guy, and he was hard to find, and it would have been really easy. And trustee, just have it put right in there. The notary was all done and everything. It wouldn't have been a problem. Well, yeah, but I could have ignored it and just said, go drill the well. I could have corrected the document, gone back to the party to have it executed correctly, or I could have cured the required words to the title and notarization. It was tempting, but then I thought about, I don't know if y'all heard of John C. Haywood's well-known presentation. He said the top 10 things landmen do to irritate their lawyers. In that paper, he discussed it was something eerily similar to this situation, but it involved forgery, criminal activity, misrepresentation, a lot of things that I didn't want anything to do with, and that put me on the right track. So I just told my employer, said, here's the deal. I'm going to go back and try to get it signed. You need to make a business decision if you want to go ahead and move that rig on or not. And to the best of my recollection, he went ahead and moved the rig on, and we ended up getting signed. So it worked out. Okay, so what do you do? Call Saul, Landman, Breaking Bad. It happens. So what happens when they stray from these principles? Here's a real-life case. Smith Energy versus Hardwick. What are the facts of this case? In 2008, Smith Energy contracted with a landman, Mark Hardwick, to provide land services in West Texas. He did title searches, purchased oil and gas leases, cured defects, all of that thing. And then Smith compensated him with cash, and he also earned assignments in not only overrides, but in this case, actually minerals, which is kind of nice and unusual. August 2011, so about 3 years later, so they'd had this relationship going quite a while, there was all of a sudden this dispute over reimbursement of expenses. The landman resigned all of a sudden, and he refused to perform any more services. So Smith sued Hardwick. He alleged that the landman's sudden resignation compromised the obligations that Smith owed to the other investors. He forced the company to retain a substitute landman at additional cost. Also, that Hardwick engaged in double billing and hours not worked. And actually, I read where he billed for times he was on vacation. That was substantiated. So he also duped the company's president into signing a certain amendment by misrepresenting the amendment's contents. He wrongly refused to turn over proprietary title information, and breach of fiduciary duty, breach of contract, fraud, and civil theft. In addition to requesting actual damages, exemplary damages, and attorney's fees, Smith requested forfeiture of all compensation paid, including all assigned mineral and overriding royalty interests. The jury found that the landman committed fraud and theft and awarded Smith, represented by Rusty Harden, an $8.5 million final judgment against the landman. The case is currently on appeal. Now, I don't want to finish on such a downer. It is a downer, isn't it? But listen, let's note that there are these types of cases out there, but they're few and they're far between. Generally, the AAPL landman is honest, trustworthy, man or woman that strives to live by the code of ethics to which each one of us are bound. So, what do we take away from this? We want to be fair, honest, and courteous with dealing with everyone in the industry, both friend and foe. We want to be faithful and loyal to the client. We have a fiduciary responsibility. And we don't want to use ploys when negotiating an agreement. We want to be prudent, thoughtful, with all the information that we give out. Don't volunteer all, but when asked specific questions, answer truthfully, but with nothing added in, and remember to use practical disclosure. So, final thought, be consistent. My pastor told me recently about a boy who brought a note home to his dad from school. The teacher wrote, "Your son has been stealing pencils off of my desk." Dad was very disappointed, and he told his son, "I can't believe that you would do that. If you had only told me you needed pencils, I would have brought you some home from the office." Here's a bad thing. I had to hear that twice before it finally clicked in. That was bad. So, hey, let me see. I think, yep, there I am. I think that's it. Are there any questions, thoughts? All right. Thank you all very much. Thanks for the opportunity.